Hello everyone. We came together for our book, which will be published very soon. The book is titled Laws Change, Oppression Remains. Of course, we would like to discuss all this much more. We are 4 people here today, but there are other people who have contributed. Unfortunately, we cannot hear the sound very well for our speakers. Özlem Cıngıl and Emel Atatürk Sevimli will be speaking too. Unfortunately, there are interruptions to the sound and therefore we cannot understand everything that the speaker is saying. We will be discussing this question all together. This started in 2018 when the Don't Remain Silent program, in order to defend human rights defenders, started. In 2022 we put out a report which was titled Don't Remain Silent, Intimidation Policies Towards Rights Defenders 2015-2021. So we see that the concept of terrorism is instrumentalized against the defenders of rights, and so we dwelt on this as a special topic. Unfortunately, the problem is going on and there are constant interruptions to the speech of the speaker, and therefore not everyone can be understood. We started out by studying the mechanics of this. Our colleagues will be explaining to you what all this was about. The speaker is Burcu Ballıktaş Bingüllü. We do hope that you get an idea of what the book is about and that you like what you hear. Now Özlem Cıngıl will be speaking. Thank you, Burcu. Welcome everyone. As Burcu said, with the retrenchment of the civic sphere, And we saw that one of the methods that was used was to target rights defenders. This we pointed out in all the work that we did in this area. The Anti-Terrorism Act was a very handy instrument for this kind of intimidation of rights defenders. So we decided to approach the Anti-Terrorism Act and the legislation related to that from a historic perspective. Now I will be talking about certain aspects of it and then turn over to Emel. When we were approaching this from a historical point of view, actually we should emphasize that today, even today, this attitude of relating defense of rights to terrorism is continuing. So what we call the anti-terrorism legislation, all the laws and the regulations that are derivative of these laws, of course, all relate to the fundamental act, which is called the Anti-Terrorism Act. We wanted to look at how this was promulgated, and of course, the Turkish criminal code historically was also a basis for this. So there are other aspects of this totality of laws related to the whole legislation of struggle against terrorism, so to speak. So we started to analyze all this, but as I said a moment ago, because rights defense is continually being related to anti-terrorism itself, we decided that it would evolve into the relationship between the two. In order to explain this, you will be seeing today a periodization of the development of this area of the legislation. I would like to say that there are different periods here. We decided that the periods were the following: 1980, 1990, where everything was rearranged, legally speaking. And from 1991, from the abolition of the several articles, very repressive articles of the Turkish Criminal Code, all the way to the adoption of the Anti-Terrorism Act. From 2001 to 2005, there was a period of democratization when the European Union came in, and there was a whole lot of changes in the legislation. Then from 2006 to 2011, there was a path of development towards democratic regime. Then there was this very brief period between 2012 and 2015, which was a kind of test, so to speak, to see if things could change, but it didn't work. Then the other report that we had done that Burcu talked about, was concerned the years between 2015 and 2021. Therefore, we stopped at 2015. So with this periodization, of course, has to do with legal, political, economic, and foreign policy aspects. And within each period, we try to see how things were influenced by these factors. in each period, the anti-terrorism legislation, well, to whom were these implemented? What principles were in the forefront, and how, although there were changes, there were also continuities? The conservation of earlier provisions was an important aspect. From the point of view of the legal aspect, when we look at it from a legal point of view, of course, laws, the prosecution, the attitude of the judiciary, all these were very important here. There is a continuity between the different periods, and there are certain patterns that can be observed which provided this continuity. Let me talk about these patterns and then turn the floor over to Emel. The first pattern is the fact that earlier provisions re-emerged in different form in the new period, although they were eliminated from the legislation. For instance, after we saw in around the early 1990s, the abolition of Articles 141, 142 and 163 of the Turkish Criminal Code. These were accepted in 1926 under the impact of Mussolini's Italian Criminal Code, and they were abolished in the early 1990s. But there was um, the, within the problematic articles that I mentioned, in 142, there was also the question of separatism. Now, this was transferred from the Turkish Criminal Code, where it was totally rescinded, to the Anti-Terrorism Act, Article 8, in this precisely the same manner almost. When we look at the reports by civil society, rights defenders really faced 142 before, and again Article 8 of the new Anti-Terrorism Act. In the period which started with 2001, Article 8 of the Anti-Terrorism Act was rescinded, but paragraph 2 of Article 7 was used in order to continue the same kind of prosecutions in very many cases. There are many, many changes brought about to paragraph 2 of Article 7 in the following years, because there were attempts to make this paragraph compliant with the standards of international human rights law, but the essence remained. Then there is the pattern of remaining in the shadow and opening up the way for new applications. Now, remember Article 8. Well, there are criticisms because Article 8 continued Article 142 of the Criminal Code, but then, although there were alleviations of certain consequences, the provisions continued to exist, because when there was alleviation with the punishment, new provisions and articles come forth. When new cases come about, although the application of Article 8 was narrowed down. Then, at this time, Article 312, for instance, comes about, the provoking the provision about provoking the populace to grudge and antagonism, or again of the Turkish Criminal Code, Article 159 in its old version and 301 in its new version, the contempt towards Turkishness, the Republic, and the institutions and bodies of the state. This, of course, shows us that the essence always continues to subsist after changes come about. So it really is embodied in the new legislation. So 312 of the old Turkish Criminal Code becomes Article 216 of the new Turkish Criminal Code. Then another star is born, and staying in the shadow and is the lot of some of the provisions. For some, it is a star born and becoming brilliant. And this is the case with Article 6 of the Turkish, the Anti-Terrorism Act. And then this is an article that is implemented very, very frequently. This is paragraph 1 of Article 6 of the Struggle Against Anti-Terrorism Act. This is targeting public officials who are tasked with fighting terrorism. And in this period, the sanction is fines, but then this can be turned into imprisonment. And until very recently, this wasn't used very frequently, but now no member of the judiciary can be criticized because there is an attack on the basis of this paragraph of Article 6 of the Anti-Terrorism Act. Now, Emel, I think, will take the floor after me, and I leave the floor to you, Emel. Here is the word to you. Thank you. I would like to thank our speakers and all the entire audience. When we look at the aspects that are different and the same between 1980 and today, well, after the coup, of course, hundreds of thousands of people were arrested or detained, and of course, laws and the constitution were abolished, and there was widespread violence applied to hundreds of thousands of people. And we know that the reason behind this was to create an obedient society, starting from the constitution, the law on political parties, the unions, the Trade Unions Act, and all the Associations Act, everything almost that had an impact on democratic life. Around 660 laws were either totally abolished and remade or amended. And the survival rhetoric shows in the reasons, the articles on the reason of these laws, or within the laws themselves. There were, of course, problems with the Council of Europe outside. There were hundreds of thousands of prisoners inside, so there was torture. There was, of course, hunger strikes and death fasts, etc. Then there was solidarity on the basis of around the families, and a great human rights movement started to form, and the strongest institutions were established then. The Human Rights Association or the Turkish Human Rights Foundation were founded in this period. Then we know that the Anti-Terrorism Act was promulgated in the 1990s. Then Turkey also tried to um, um, really ameliorate its image with the Council of Europe and the rest of the world. But then, with the Kurdish question becoming more and more topical, there was great oppression of the Kurds and also political opponents on the left. Rights defenders, journalists, and political people were repressed for different reasons. Some lost their lives, some remained in prison for a long time. There were some scheming organizations such as JITEM and Susurluk. And then there was the longest government in power in the 21st century from 2002 to today. Then there were openings at the beginning, overtures, so to speak, towards the Kurds, towards the Alevis, and then the signing of certain conventions promulgated by international human rights organizations. But then this turned into a kind of repressive regime after a certain while. When we look at the 80s, 90s, and the 21st century, in great scale events such as the massacres of Sivas, Çorum, Maraş, etc., or with respect to organizations such as JITEM or Susurluk, the Anti-Terrorism Act was never implemented on these people who created all this scheming around so-called anti-terroristic acts, but were always used to attack those who fought for rights. Well, the first thing one has to say about this is that crimes and punishments really depends on political conjuncture, alliances, parties, and the relations between the opposition and the government in power. Um, in other areas, in certain areas, some crimes were simply ignored, but in others they were punished very heavily. Secondly,
we can talk about the use of constitutional rights being related to terrorist activities. So in the 80s and 90s, compared to the 2000s, legal norms were in a way more valid. However, come 2000s, we have arbitrary practices, uncertainties, these are increasing, and laws and articles of the laws are actually used to punish people very easily, regardless of the fact that there is a legal basis or legislation for that. So during all these times, there are certain specific groups that are always labeled as terrorists, such as the representatives of civil society organizations, dissidents, members of the press, members of the LGBTQI groups. And come 2000s, we can see that even people who are refusing to convert their foreign currency to Turkish lira, or tradesmen who are stockpiling commodities, can be accused of being terrorists. Since that time, we have seen 8 different judicial packages that were put into practice, none of which worked. We know that the laws anti-terror law and other laws are not in line with international standards. There are tens of reports about that. We as right defenders have been fighting against this for a long time. It's very important to overcome these problems. But the main issue is that even though we had perfect laws with no faults, still there is a problem in terms of the mentality of the members of the judiciary to implement these laws. Let me just give you an example. In 2013 and 19, the anti-terror law was amended twice, and the expressions in press coverage were made no longer a part of crime, but this was not the case in practice. This was never reflected in the practice. The editors-in-chief were prosecuted, so this is a good example that the law was not actually implemented. So any illegal, unlawful practice is always explained as fighting against terrorism. So this is a common pattern that we see in the 80s, 90s, 2000s. So the civilian tutelage was replacing the military tutelage, or however you name it. So we had this habitat of nationalism and racism, and this environment, this nationalist and racist environment, also fed further all these problems. So the problem is not local, it's a global issue. We are very aware of this. So the neoliberal policies are now defining a huge human rights crisis and a rule of law crisis. Only 2% of the population in the world are living in places, in open countries where freedoms and rights are respected. In the remainder of countries, we have authoritarian regimes, and now countries are not ruled with foreseeable and clear laws, but there is total uncertainty, and countries are governed by statutory decrees, decrees having the force of law, including Turkey as well. So now countries are performing so poorly in their human rights scorecard that nobody is trusting in these countries anymore. Of course, we have regional mechanisms such as European Court of Human Rights, etc. And now the ethos of these mechanisms is also weakened. No one is trusting them again. But despite all these things, we as right defenders and members of the civil society, we are still fighting for our rights and trying to remind the government of their constitutional and contractual obligations, roles, and responsibilities. So to sum up, let me conclude by saying that the research subject to this panel is not an academic research. It's not an academic study. We have to underline this. We are not trying to answer all questions regarding this issue, but the main purpose is to assess this arbitrary implementation of the anti-terror law and to show how easily everyone can be associated with terrorism at one point. So this country in the past had ministers, prime ministers who were prosecuted and executed because of violating or breaching the constitution. Then the same country also brought amnesty to those people, and in these countries we have had people who have become victims of human rights violations. So we have to see that it's not a legislative issue only, it's a broader problem. So we cannot solve the problems by enacting reforms only, which we saw did not work anyway. So we have to have a broader perspective in this habitat, so to speak, and I hope that our study will make a contribution to these efforts. Thank you so much. İdil, over to you. Yes, after Emel and Özlem, who explained the methodology of the research and gave information about the research. We will continue with the panel. We're very excited to be here to share with you this long-term initiative research, and we are here together with very valuable speakers representing the civil society in Turkey. Thank you so much for your participation. As mentioned by Emel and Özlem, this research shows that although the governments and laws change, anti-terror practices in Turkey always are used as a judicial harassment tool to silence certain groups and specific groups, specific people. So we try to bring together different panelists who are lawyers, journalists, who will bring their professional background, but they are also going to share their personal experience regarding judicial proceedings whereby anti-terror law was actually abused. We have other fields, of course, to talk about. As mentioned by Burcu, starting from autumn, we will have different activities and panels to talk about these other issues. So without further ado, let me introduce our speakers. Our first speaker is Eren Keskin, lawyer and rights defender, member of Human Rights Association since 1989. She's among the founders of the Legal Aid Office Against Sexual Harassment and Rape in Custody from 2013 until 2016. She was the managing editor of Özgür Gündem newspaper. She has been sentenced to a total of 26 years in prison, and she is also the co-chair of Human Rights Association. Our second speaker is Ali Turan Topuz. After, well, he has been a professional journalist for 17 years at Radical newspaper, and he has published poems, stories, and literacy criticism in various literary magazines. And our third speaker is Nuray Özdoğan, member of the Human Rights Association, Association of Lawyers for Freedom, and the Association of Progressive Lawyers. She also is served as the co-spokesperson of the Law and Human Rights Commission of the People's Democratic Party and the People's Equality and Democracy Party. And she has actively took roles as a lawyer in high-profile cases such as the October 10 Ankara massacre trials, Jitem Ankara and Kızıltepe trials. Our fourth speaker is Serdar Tekin, who completed his PhD in political theory, and he was dismissed from the Department of Philosophy at Ege University, where he was working as a lecturer with a state of emergency decree for signing the petition titled "We will not be a party to this crime," commonly known as the Peace Declaration. His publication, State of Emergency of the Universities, a study on the destruction of academic environment, was published by the Human Rights Foundation of Turkey. So welcome to all our speakers. We will start with Ms. Eren Keskin, who will talk about how the anti-terror law was used against civil rights defenders and civil society representatives. As a person who was personally accused of being a terrorist by under this law, what is your take on these practices and these court cases? Of course, in this discussion we will talk about 1980 and afterwards, but I do believe that the founding ideology of our the Republic of Turkey is always determining in these discussions. We are living in a region or geography of genocide, and the genocide mentality established the Republic. Mahmut Esat Bozkurt was the person who was one of the founding fathers of our legal system, and we know that he had a racist discourse that was reflected in the written law and legislation as well. So we have to think in a comprehensive manner, but as we have limited time, today we will only discuss the post-80s period. So I became a part of the human rights movement back in 1989. Of course, since the foundation of the Human Rights Association in 1986, I was involved in their activities, but I took active part after 1989. At that time, as you also mentioned, we had articles 141, 142 that were actually used against the dissidents mostly. But as I believe, I have to say that the Republic of Turkey has a very discriminative legal system. But unfortunately, people living within the boundaries of the Republic of Turkey who call themselves dissidents are facing double standards. The same official ideology, the same progressive approach is defining the discourses. Yes, we have discussed articles 141, 142, 163, but we never discussed 125 because it was only used against the Kurdish people. So we have to have these discussions in a manner as the human rights defenders who are facing these discriminative practices. We have seen the General Congress of our organization, and during our General Assembly, Vedat Aydın really shocked everyone by speaking Kurdish, because speaking Kurdish at a General Assembly was a shocking thing. So Vedat Aydın delivered a speech in Kurdish with a very radical content. Then he was taken into custody and further arrested. And we have learned that law in a very burning manner, and we learned that it would be used against us and implemented against us. But at that time, I think that was impactful. Vedat Aydın's case was a milestone. So that law was abolished after a certain period of time. However, the 1990s were really frightening periods for us. I believe that the mentality of the state has not changed, but the methods have changed. For instance, in the 1990s, we were being prosecuted again. At one time, I think I was subject to 200 prosecutions. Another colleague had more than 160 prosecutions against him. Anytime we made a statement, they would press charges against us. At that time, by the way, I would like to give personal examples. At that time, Article 8 of the anti-terror law was the most frequently used law to prosecute us, because if you're using in your speech or in your article the concept of Kurdistan, you would immediately be prosecuted. There would be an investigation against you, because at that time practices such as losing people or people being disappeared in custody was a very common practice. We were receiving threats, death threats, we were even facing armed attacks. But in terms of freedom of expression, yes, there were constant prosecutions against us. Cases were filed, but arrest decisions were not this arbitrarily given at that time. I remember very clearly, if there is an investigation against us due to Article 8, we would go and give our statements. We would give statements with very radical content. But the prosecution and the investigation would continue without any arrests. The case would be filed, we would go in the court and express ourselves radically. We would discuss the concept of Kurdistan. We would be sentenced only if the High Court approved the sentence. We would go to prison. It wasn't like today that and we wouldn't be immediately arrested the moment you go to give your statement. In 1995, I was sent to prison because I was sentenced because of Article 8, and many intellectuals, Fikret Başkaya, Halut Gerger, Ismail Beşikçi, he was always in jail anyway. So many intellectuals were imprisoned, and there was a certain public opinion that was created. At that time, we had the EU negotiations. So they made a slight amendment in Article 8. They alleviated the sentence. So after 6 months after I was imprisoned, I was released because the law was amended. So our statements were taken again, and they released us. However, this trend did not continue. We continued to face actually legal attacks. I remember very clearly when we had a case of torture, or especially in Kurdistan, when it was about violence against women or torture, when we talked about these things, we would immediately be prosecuted. At that time, they were using Article 159 of the Turkish Penal Code at that time. So Article 8, after Article 8, this was the most frequently used article against us. And I also have to say that Kurdistan was always ruled by a different legislation, so to speak. That was always the case. Laws applied always differently to Kurdistan. So after having said that, I would like to share with you the following, especially sexual torture against women in the region. We provided a legal office opportunity for women. So when women faced sexual torture in custody or in their households, when there were police riots, we wanted them to talk about this. At that time, we were working with doctors Şahika Yüksel, me, and lawyer Şayka Karakaş. We were actually prosecuted for aiding and abiding the terrorist organization. We were going to the prisons. We were receiving applications from women who were subject to sexual torture. So they said this was a terrorist activity, and they prosecuted us based on Article 169. So we were tried for that. And I have taken some notes. By the way, I'm trying to remember what I have noted here, as we have limited time, but we really suffered a lot from this. And then during the anti-terror law, with the abolition of Article 8, we also have seen a partial change in the structure of the state. As you also mentioned, the initial phase of AKP was a period when the government was in a fight with the state.
Well, there was even a case to close down the AKP itself, but then we went into a much worse period. And with respect to the Anti-Terrorism Act, well, because it was so much discussed, Article 8 was abolished. But what happened? We know this very well. Whatever you do to change laws, the Republic of Turkey always finds its laws to use against you. Well, then they went over to Article 7 of the Anti-Terrorism Act with the same method that's continued. And after the change in the Turkish Criminal Code, another law that was used against human rights defenders, it was Article 301 of the Turkish Criminal Code. But I would like to point to a detail here. With respect to 301, because of the Armenian genocide from 2005, as the Human Rights Foundation regularly, we talked about the genocide. From 2011 and all the way to 2018, we did this on the street, and never was this prosecuted or investigated even. So there was this toleration on the part of the state. But then after 2017, this was banned, prohibited on the street, and then there were investigations. Then in 2018, investigation was opened up on the basis of 301, but then the prosecutor's office said this is freedom of speech, but then the investigations continued. Now, outside of two cases of punishment this year, there were no cases that ended with conviction. So they did this all the time, but never were there convictions. Well, they don't want these to be talked about. That's what it is, because the diaspora is very strong. There are states that recognize the diaspora's theses, and there's very strong evidence that there was genocide. So the state does not want this to be talked about. That's why they do not convict the people who talk about this. But then there is a present case. We will see what the results will be. Now, I would like to touch upon the following as well. We, in each period, in this geography, we know that law is dependent and the judiciary is always dependent on other forces. There is a dependent judiciary today as well. In the past, it was dependent on politics. Well, there were different centers, there were different prominent people who had their say. It was ultimately the military that had its impact, but nonetheless there were different centers. In 2014, in 2015, all the way to that period, we talked about many things. We could find some prosecutor or some judge to speak to, but we can't now. In justice palaces nowadays, the judges and prosecutors are totally closed to a dialogue with the defense lawyers, counselors. I would also like to talk about the following. This was there were some questions on this with respect to Özgür Gündem, the newspaper. I was a lawyer of Özgür Gündem from the very beginning, and many columnists I met, and starting with Musa Anter, and the way I was friends with the columnists. Gurbetelli Ersöz was, for instance, it was the editor-in-chief, and we were part of the management. We were very young as a cadre, and so in 2013, when it was decided that Yeniden Özgür Gündem would come out again, that was a new version, and I was asked to become editor-in-chief, just the name, so that we would support them. I didn't actively participate in the editing process. During the peace process, there were no cases prosecuted against Özgür Gündem. But as soon as the peace process was over, there was a bombardment of investigations. We went to prosecutors' offices every day. I did not even know what article I was being questioned upon. The prosecutor told me that it was this, it was that, etc. But the prosecutor constantly asked me this, would ask me that. In the end, the prosecutor said, I will have to demand, there was judiciary control on me. Now, the prosecutor said, I will have to ask for your arrest and remand. So later, we started to become editor-in-chief in turn, and 108 cases were opened up against me only. And there were other editors-in-chief, as I told you a moment ago, because we were doing this in rotation. And First, it was, it was uh, prison for life that was asked us of us. Uh, of course, we lived terrible results here, and then Kurdish intellectuals were separated from this case and later acquitted. Only Kurdish people, all those people who were Kurdish, whether they be editors or columnists or journalists, uh, received punishments as members of an armed organization. I was, convicted of insult to the President of the Republic. I was convicted of all kinds of terroristic acts, etc., the membership of a terrorist organization, etc. I cannot leave the country. I cannot go abroad. I was fined many times. I will have to pay, I had to pay them because otherwise I would have to go to prison. And of course, there was solidarity, so we paid these, with the help of human rights organizations. But this is what they do. They leave you with a kind of concern all the time. You're concerned that something will happen to you in the near future, and therefore you are intimidated. And that way, the state really, we are really face to face with a terrible state structure. And then, when a murder that was committed in daylight very clearly by the partner of the party in power, nothing is done about this. This is very clear what kind of state we are face to face with. The speaker is talking about the Sinan Ateş case, and the partner in question is the MHP, that is to say National Action Party, translator's footnote. There are, of course, conventions that Turkey has signed, but there are mechanisms through which these, when contraventions against these conventions can be pursued, but this is not done for Turkey, and so everything is going on as before with slight differences. Yes, thank you very much. The changing conjuncture, there are ups and downs, and then uh, really exploding different kinds of punishments and persecutions. Well, the question of the European Union perhaps we can take up during the question and answer session, because let me remind you that this is the questions that are posed are compiled by our colleagues, and therefore these will be later asked. Now, I would like to continue with Ali Duran Topuz. The Anti-Terrorism Act is being used against social media or other media institutions and newspapers and TV channels, etc. What, as a journalist, what do you think about this? We cannot hear the speaker. Apparently, there's need to unmute. Yes, now we can hear him. I greet everyone. Thank you for this invitation and for this encounter. And I congratulate you for the work you have done. This was very informative, and I understand that the book is very important and gives us food for thought. And you have done your work very appropriately. Because our time is limited, I cannot really dwell on cases in detail. I will take another path. Some of what I have in mind, other speakers have mentioned as well, so there is no need to repeat them. I will be talking about the conceptions of law that dominate certain periods and certain proceedings and cases that stand out for as examples of these conceptions. First of all, Eren reminded us of the Armenian genocide and said that there was a code, a set of codes of the foundation of this republic. I agree with her, but my distinction is a bit different. There is, I think, a three-partite legal structure in Turkey. Different cases show this. For instance, what Eren talked about with respect to Özgür Gündem and Vedat Aydın is one case. This is since the Ottomans, this is valid since the Ottomans, two different laws coexist. This is an ordinary law and an extraordinary law coexisting. We cannot see this in the West, but Serdar Hukuk will be talking about dual legal structures, but usually in the West, this is a matter of alternation between two different legal systems. But there are ups and downs in the change in the law. But in the Ottomans, there are two different kinds of law. There is the Sharia law and there is the law of everyday life. There is an addition to this. This is the meaning of 1915. Within the westernization process, 1915 really comes in with the idea of homogenization of the nation state, and there's a decision in consonance with this of destroying the Armenian people. This is a colonial kind of law, of course. And from the Constitution of 1924 on, this is really a kind of tradition now, a continuation exists, and this is the Tunceli law. This is the kind of law that makes it possible to destroy a certain people or a certain community in the fastest way possible. For instance, the commander of martial law is given the authority to adjudicate, to prosecute people. So this is a colonial kind of law. The Anti-Terrorism Act is really when Turkey started to be ruled by extraordinary law legal structures from 1980 on, we used to see interventions where human rights were totally eliminated. But there was a certain legalism here. That is to say, the law on torture usually was a method, but the method itself, the torture itself, was used in order to hide certain things. But with the Anti-Terrorism Act, the colonial law came back with a revenge and became part of the system. So I think the anti-terrorism law can be reflected on together with the Tunceli law. For instance, the disappearances, very common detentions in Kurdistan should be thought of in these terms. After the adoption of the Anti-Terrorism Act, this should really be thought of as a constitution, because the Anti-Terrorism Act is really the source of the law in Kurdistan, where all these extraordinary legal structures are implemented. And these forces really are not part of the legal system, and therefore the Anti-Terrorism Act and its derivatives act to protect these illegal organizations of the state. The Fikret Başkaya, the Haluk Gerger, the Yaşar Kaya cases, and others all are part of this structure. But when you look at it carefully, in general, the general prohibitions with respect to books and journals and whatnot from 1987 on, especially with the foundation of the Belge Public Publishing House, and is really centered around the Armenian question and the Kurdish question. And all these books are seized that are published on the Kurdish question, on the Armenian genocide, and the publication of books are considered to be demands for Armenian or Kurdish, whatever, separation, etc., etc. And then there is another moment here, the 2001 and 2002. But I would like to point to two things with respect to the 1990s that we haven't seen yet. All this pressure, all this repression, and all these disappearances and the detentions and the torture and all that, when all this was being done, both in the 1980s and the 2000s, then there is a solidarity culture that developed against these repressive practices, and a very strong defense. There are very illustrious lawyers in these two periods. The same happened right after the 1980 coup. But outside of these, there are no illustrious lawyers. What Eren Hanım talked about, refers back to the 1990s. Today, lawyers don't become illustrious, famous because they are lawyers, but because they are targets themselves. Tahir Elchi, for instance, who was one of the very important lawyer in the 1990s, in the 2000s, became a target when he did not accept to concede to agree to the idea that the PKK was a terroristic organization, was killed himself. Then there is the extraordinary law, there's the extraordinary law, there's the colonialist law. Then there is a new process, the anti-law. This is a kind of new refoundation of the state. There is no evidence really looked for. There is no logic for convicting people and handing down heavy punishments. Many people, for instance, was opened in the indictment of the terrorist organization's case that was leveled at me and many other people. There is only the number of the law, nothing else. And between 1985 and 1995, all the books that are banned have to do with the Armenian and Kurdish questions. In the 1990s, there were radical revolutionary left organizations. The Anti-Terrorism Act was used against these as well, but now it's become totally peculiar to be used against the Kurds. And between 2001, 2020, there was a kind of a calm period, but because the uses of this law were targeted to be maintained. We saw many struggles against the AKP, but many extra-legal struggles were carried out. There were, of course, the forced disappearances and murder under detention, etc., etc. And one of the most important examples was, of course, the Hrantnik murder. And this story can really be seen as a turning point for this story, both with respect to the Armenian and the Kurdish question.
So there was this case to opened against AKP to shut the party down, and there was this memorandum that threatened the party to remove it from government. So until that time, the party in power, AKP, was seen as a threat. After that time, it immediately started to engage in a reconciliation with the founding mentality of the Republic of Turkey as defined by Eren Keskin. So we have 4 different periods until 2015, and when we come to 2015, in a very interesting manner, all the articles restricting the law and that mentality comes into power. What do I mean? The racist, nationalist party and the Islamist party, welfare party's continuation, AK Party, AKP, they came into power. They were themselves subject to the prosecutions under Article 163. They were targeted by that anti-terror law. For instance, there was this 10% political threshold that was introduced after the 1980 coup attempt, and that was there to prevent the Islamic parties to coming into power. However, the Justice and Development Party protected the threshold article against the Kurdish people. So they actually wanted to have the power to get that protection against anyone. So in the post-2013 period, the resolution process actually left some traces regarding some softening. However, all the 4 consecutive judicial packages that were introduced included very dangerous legal threats that would actually make the improvements made meaningless. In the beginning of 1990s, monetary fines were frequently used. Then they partially gave up on this because a monopoly being established in the media created an important impact. The entire media was dominated by the government or the state, let's say. So leftist and socialist publications were weak anyway. So we were only left with the Kurdish people whom they wanted to prevent from engaging in any discussions. So the terrorist organization and everyone around them were being fined. So administrative fines or monetary fines was weakened, and it slowed down. Yaşar Kaya and many other Kurdish people, or people who, intellectuals and journalists who supported Kurdish people, were subject to monetary fines. After 2005 especially, this practice was not that frequently used. And by the way, we have to pay attention to another thing. As all these things were happening, generally speaking, the media and the academia and their attitude was not is not very much discussed, but it was very determining. For instance, when you watch the mainstream media in 1990s, or when you take a look at the academic activities in the 1990s, or the academicians who were raising their voices, who were courageous, for instance, apart from those names, a few people who were raising their voices, we see that not everyone was actually saying anything against the attitude of the government in terms of colonialist law and this extraordinary law. They were actually defending, these people, journalists and academics, were defending the mentality of the government. And the opposition against legal improvements came not from the military people, but from mainstream media representatives. Almost all the writers and columnists in the mainstream media were supporting the process. And there was this severe denunciation process. So certain articles of the law were highlighted, certain people were targeted, such as Tahir Elçi, Hrant Dink, Ahmet Kaya. So these people were targeted because of the function of the media. So the media was not supporting freedom of expression and opinion or assembly, but it was against it. The mainstream media positioned itself opposing the rights and freedoms. So what happened was that the Justice and Development Party tried to create a structure that directly linked all these institutions to itself. So the party started to establish a new structure, a new government model, and repression was increased. First, the anti-legislative mentality was enshrined, and a right that is protected by a certain law was actually violated by the same law. So we had the colonialist mentality that was put into practice, and in colonialist law, what happens is that with the state of emergency law, there are certain restrictions in terms of rights and freedoms. However, for colonialist mentality, when the colonialists face the natives, for them to accept them as human beings, it takes a lot of time. And colonialists think that the natives are a commodity, they can be easily destroyed, no one can even discuss that. So this triple mentality, anti-law, colonialist law, and emergency law became the main law in Turkey now. A new state is established. The nationalist Kemalists were the guardians of that mentality, and then came the nationalist and Islamist Justice and Development Party that came into power. So we cannot understand any of these processes by looking at the legal processes. The structure that holds the power, their leaders, spokespeople, and their words are considered as the law in practice. This is the period that we are finding ourselves in. I'm sorry I have taken too long. Maybe I was a bit confusing as well. Maybe my words were not that clear, but that's what I generally tend to do. Sorry for that. No problem. Thank you so much. This was really a very comprehensive presentation. Especially you talked about anti-law and legalism, and Ms. Eren also said something similar. The judicial harassment is always there. Prosecutions are being made, investigations are carried out, but in the end, there is always an acquittal. There are court cases that are filed that shouldn't have been filed at all. So maybe after the next two speakers, we can also discuss further during the Q&A session. Next is Nuray Ezdoğan. Since 1980s, certain laws have been used to make the political life a monolithic life. And now the anti-terror law is being used or instrumentalized to continue the same process. So you are a lawyer who is closely following up on these cases. What would you like to say? I think your mic is muted, says the moderator. Can you hear me now? Yes, we can. Okay. I would like to greet all the participants with love and respect. Eren Keskin and Ali Duran Topuz gave us a very comprehensive context, how the anti-terror law was enacted, how it changed. First of all, we have to understand the main political axis of our country, the Republic of Turkey. We have to understand the founding mentality of the country. Otherwise, we cannot understand the anti-terror legislation. Yes, in 1990, the Anti-Terror Act was put into force. Remember those days, that period. The Kurdish political struggle was on the rise. The Kurdish people started to politicize their social demands. And I interpret this as follows. After the 2000s, military approaches were more dominant. The existing Turkish penal code was sufficient, so military approaches were used, but then things have changed. Of course, social relations change, production relations change, economic relations change, and also the means of political oppression also changed, and they were used more effectively. Yes, we have gone through a resolution period, but generally speaking, after the 2000s, although we had certain judicial packages, this was the dominant figure in this process. As we have very limited time, I will just start by talking about the period in the aftermath of 2014. So the main codes of the government did not change. It's just the governments that change. But the changing governments, including the AK Party government, although we have an Islamic party in power now, Turkey has always been and is still a military country. We still see the results of the military practices in the enactment of the legislations, in the judicial processes. In all processes, we see the remains and the legacy of this militaristic understanding. Yes, of course, the neoliberal policies changed the methodology for this. For instance, beforehand, political demands were rapidly punished by using the Anti-Terror Act. Now, the Anti-Terror Act and the Turkish Penal Code are no longer the only two codes that they use. All the legislation, all the laws of the country, including the municipal law and the legislation on municipalities, every piece of legislation in Turkey is now used as an instrument to punish people. That is why judicial harassment, judicial repression is felt more and more in this period. So we are witnessing altogether such a period. Political punishment or punishing political struggles are now punished through different instruments. So the instruments have changed. The Kurdish political movement at that time established this structure to realize, to fulfill the political demands of the Kurdish people. The parties that were established for that were closed down, and HDP was the longest surviving party, legally speaking. So, but was it really alive? Did it really survive? No. They have oppressed or repressed the political life in so different ways that they were even more effective than physically closing down the party. So we're talking about judicial processes, the system of judges, the High Council of Judges. So in the period 2015 and afterwards, these instruments were more and more effective. Of course, the resolution process came to an end, conflict has increased again. And with that, the components of the state have changed. Yes, the main structure was there, but different alliances were formed. So within these alliances, jihadist organizations can also be included. Less radical elements can also be included. So now the government is actually surviving through a different structure, although the main structure, the main pillars remain the same. And in the process that we are going through, when we compare the political life with the past, engaging in political activities is now the most difficult thing to do. So this is the period where political activities are the most difficult to get engaged in. Of course, in different periods, we have faced different challenges. At one point in time, you did not even know you would go back to your house in the evening safely. You would still be alive, for instance, but the Anti-Terror Act should be considered together with the execution or enforcement law. However, we are seeing the biggest changes in the enforcement process in the prisons. There is a lot of uncertainty. Legal assurance is no longer there. So the process is actually very clear from the perspective of the mechanism that is carrying out this process. I think there is a very planned and stable implementation in terms of the decisions. All the decisions that were taken at the National Security Council in 2014 are still being implemented. Yes, Mr. Ali also talked about torture and other things, but now we are talking about intelligence. So intelligence notes are now considered as enough evidence for prosecution. So people are potentially coded, and with that potentially coding, they are being tried and sentenced in this period. So legality is no longer there, because as a state, you get your legality from the law, right? But there is no such legality anymore. That's the period we're going through. And the state, the elements that the state sees as a threat are crystal clear. There is incredible violence against those elements. There is judicial violence, military violence, law enforcement violence. But of course, the main code, the core code of the state is all about shrinking the Kurdish political movement, politicizing the social demands, and of course the function of the judiciary became more and more important during the rule of AKP. It's now more important. We used to say this: we stay for too long in the courthouses because the court cases take too long, days, weeks, and months. But the cases are conducted based on intelligence activities. The way the defense is being coded, the approach towards the accused, even the organization of the courtroom is based on this. Add to that the enforcement regime and the implementation of the enforcement regime. So we can say that the legal processes and law are effectively used by them. Well, this is a dialectic process, but it's also destroyed. The legality basis is also being destroyed in this process. For instance, many things that they call as anti-terrorism activities are actually used to oppress the political field. We have seen days whereby the laws were changed overnight and the decisions were changed based on the law. HDP and DEM Party, People's Equality and Democracy Party, are facing incredible oppression at the moment. There's a huge crackdown on these parties. We can't even express this with words. So in terms of its functioning, the state is very centralized and is acting as a very centralized manner, criminalizing every single person stepping into the branches of the political party, making it impossible for that political party, for DEM party, to function. The entire mechanism is based on that purpose. That's what they are doing currently, because these demands the political demands being fulfilled is causing the state to use different methods because they cannot prevent these demands by closing down the parties. Many places in Kurdistan are now being publicized or expropriated, let's say. And the same thing is true for the trustees. That period is not only about interrupting the political will.
Really what they're trying to do is to eliminate your capacity of representation, to alienate people from the party. But what's most important is what Ali Duran Topuz talked about. The, there is the attempt to establish a structure that is past the point of no return. Was it successful? Well, many forays have been made, but the overall this is not successful. But there is no legal ground now. This is not a legal ground. This is a reshaping of law under colonial, the conception of colonial law. And how would you know that the Turkish um, the Turkish criminal code really Articles 37 is so popular with this. They applied in many different laws, including the Kobane case. First, we saw this in the Gezi case. They took the revolt against the state as the basis, and second, in the Kobane case, they said the spoiling of the unity of the state. Of course, there's a difference in the attitude, as you can see, and in the approach. Of course, we should really eliminate this difference on the field of struggle. That is why this your work has been done, and that is why we have participated here. And so against this repressive regime, what we can do is what we're talking about. So otherwise the legislation has really changed into an apparatus, a big apparatus. Now, with respect to the prisons, there is a difference here. They really cut the relationship of society to prisons. The COVID was very useful here. The crystal clear appearance of torture is very much in the forefront. The execution system and the cell system, the isolation system, the Y type of prisons, where isolation is much more marked. So we've gone over to that. And it's now a method, you know, this conditional release is now not used any longer for people who have punishments that are related to the national question. They stay in prison 2 years longer than the judge has stipulated, 3 years, sometimes even up to 6 years. Today, we have now gone into a period where torture is transparent and clearly present, where from a period when it was hidden and very rampant. Why do they want to go back to the regime of replacing mayors with their administrators? Because this is a system that has really uh, um, that is really bankrupt. Today, the municipal legislation, which the AKP itself transformed, it is possible for the AKP to stop the municipalities from doing anything um, on the basis of the existing legislation. But no, it doesn't. Well, in the past, certain coffee houses where people of the other side used to sit were um, shut down. I mean, um, attacked with guns. Well, there are very many coups, many things that one would like to talk about where no political basis exists and no legal basis exists, but we can't go on forever. Now, I remember very well, I was there after 2015 when the first curfew, before the first curfew was implemented, 24 people were shot and killed by sharpshooters as the uh, jurists with Freedom Jurists Association documented this was the method. Sharpshooters killed these 24 people, not in conflict case situations. So, what can we do? One, we have to exhibit what's happening and to attribute meaning to what is happening. The intelligence organization is now really involved in legal cases. For instance, in the process of the Kobani case, the um, files are not in the justice palaces. This started in 2016 when we were pursuing the Jizre massacres. We found out that these were not the places where uh, file cases were, case files were. Why do I stress this? Yes, there is an uncertainty, but this is not because there's uncertainty with respect to the government in power, but this is really a consequence of the violence that is done to us. The same happens with law enforcement. Now, there are special procedural uh, situations. There are certain cases where prosecutors, for instance, are constantly reappointed in a case. So you cannot really say that this is a case that is um, adjudicated on the basis of due process. This is, it's not the case that cases are decided within the courts themselves. This is a process which makes law something that is not demanded any longer. Perhaps there is so much violation that why is there so little international um, pressure on Turkey? Well, yes, um, there's an increasing number of submissions to the European Court of Human Rights, but this is incommensurate with the increase in the repression. When Shirnak was brought down, or other cities and towns were destroyed, it was not only people who were killed; it was the whole physical structure of cities that were brought down. In that process, all the judicial processes were locked at a certain point, and the whole thing was locked with the contribution of the European Court of Human Rights. Of course, this was in favor of the Turkish state, and because the process was blocked in the European Court of Human Rights, this brought down the number of cases at the court. Thousands and millions of people had their places, their abodes brought down. People were massacred. We witnessed this. Um, People did not want to submit their um, petitions to the European Court of Human Rights because you create provocative, grounds that are apt to bring about provocative processes. Well, we saw this in Van. Of course, law can only be used if there is political processes, there are political processes that help it become operational. I'm not saying that what is happening is inevitable. I mean, we are all jurists, so we don't want to say this, but we have to think about this. There's so much that is eroded that we really obtain anything in court houses? This is all I have to say for the moment. Well, this is the permanence of uncertainty and um, arbitrariness. You gave us many instances and examples. You explained very well what you wanted to get across, and that is why we did not call this a study on the Anti-Terrorism Act, but the Anti-Terrorism Legislation, because it is a series of different kinds of practices that lead us here. Now, I would like to continue with Serdar Tekin, our last speaker. Serdar Tekin, Professor Tekin, will now give us a conceptual framework, the um, policies of security conceptions and securitization in the 21st century, and how these develop in detriment of rights and freedoms. Well, the Memory Center has done something really wonderful. And each speaker spoke very well, and I would like to thank each and every one of them. I feel this as a debt of gratitude. There is something interesting in this panel. And in the report, too, in your book, there's something very interesting. The book that you have prepared as the Memory Center. As I say this as someone who has read the draft. In the conclusion, there is the following emphasis. as a human rights organization, all our reports, of course, really are topped by certain recommendations. All the monitoring activities of human rights organizations really are geared towards recommendations. And this is also a certain kind of monitoring action. And therefore, we need recommendations to be made at the end. And in that sense, the reader should understand what is being demanded. But this report will not have that kind of set of demands and propositions. Why you say this is very, very easily comprehensible, because when we bring up concrete demands on the anti-terrorism legislation um, uh, context, we find ourselves in the same habitat as the anti-terrorism legislation itself. And all speakers accorded on this. What is the political essence of this legislation? We have a multi-leveled answer to this question in the three presentation, and I find this very important because the anti-terrorism legislation, just like any kind of other legislations, has its reasons. This, of course, takes us to the question of security policies. There are formulations, that is to say, the language of the law. And there are wonderful determinations on this in the book, and there were very important observations made here. And there are lots of arrangements here. There are, in this legislation, there's a lot of uncertainty in the language of the legislation, and this is done deliberately. And this brings about arbitrariness from certain points of view, but on the other hand, a power that is unlimited, that says not limited, and a kind of power comes visible here or is manifested, and the reasons given, formulations, and all the formulae that are stipulated in the provisions. After an analysis has been done of all this, what brings this together is a political content. This is what is the unitary factor, and there were very important observations on this. When we look at this, I would like to say a few things on this, and then I would perhaps like to say a few words on the concept of terrorism in the 21st century. Now, the political essence of the anti-terrorism legislation is the emergency law. Of course, Ali Duran Topuz also talked about the ordinary law and colonial law. But together with this, we have seen that these come together. They interpenetrate, so to speak, in Turkish law. They have developed together. So this is very real. And therefore, rather than having two different appellations, two different labels, the colonial practices should be seen as there is as the eastern flank of the law of the Republic of Turkey, and the other is the western flank of the legislation of the Republic of Turkey. So the emergency law really covers the Anti-Terrorism Act. We agree on this. But not only this, this is not only a question of emergency law, not constitutionally. What is this theoretically? What does this mean? This is this is beyond ordinary laws. The deliberation margins of deliberation, those that have not been arranged at all, those that are left to the imagination of the practitioner, all these are part of this. And when we look at the details of the extraordinary or emergency law, these are always provisional, so to speak.
Is the same thing in our constitutions as well, starting with the 1924 constitution. uh, Martial law and constitutional regulations have defined the scope of these practices, saying that they can be implemented only in emergency cases. But of course, we have important examples of this. Temporary, provisional, and extraordinary powers can be granted, but there is a huge margin of appreciation when they do that. So what we call as the Anti-Terror Act or legislation, uh, when we say it's an emergency law or a state of emergency law, we see that these provisional or temporary authorities become the norm, become permanent, and the series of actors who are enforcing such powers and practices are normalized. In terms of Turkish Republic's history, this is the thing for the Kurds, Alevis, and anyone, the leftists, socialists, anyone who are agents of social struggle, who are trying to speak up to the extent they try to speak up. In terms of the current period, of course, new actors are added to these groups, new social groups are added to these people. We have now women, LGBTQ plus people, and anyone who can find the opportunity to do something from the working class, for instance. The slightest movement they have is being punished. So we are living in a permanent state of emergency, so to speak. So the Anti-Terror Act is an emergency law, a state of emergency law, and it makes sure that the powers granted by the emergency law become permanent outside the state of emergency as well. So the roots of this legislation throughout the history of Republic and how it transformed, how it continued, were actually emphasized by the previous speakers. But in the world outside our country and in our age, as emphasized by the report of Hafıza Merkezi, there are certain similarities. For instance, the concepts of terrorism and anti-terrorism, when we look at the global expansion of these concepts, we can say that starting from the second half of the 1970s, by the states that we can call as neoliberal states. Actually, this was developed together with the development of the neoliberal states. And previously, we had a different type of security, other mechanisms allocated for these activities. However, this kind of alertness or public security concepts were not crystallized based on the concept of terrorism. And now new laws are used to update this legislation. Starting from the 1970s, this is becoming more and more clear. This is not the case only in Turkey, but it's a global trend. Of course, in the global north and global south, it's manifested in different ways, and its implications are different in different parts of the world. But both in the global north and in global south, starting from the end of the 1970s, with the new security state or state of security being intertwined with the neoliberal mentality, things have changed. And this has its reasons, because neoliberal understanding is about the state withdrawing from the market mechanism, and the state not intervening in the market is demanded by the neoliberal states. But unlike the classical liberalism, it's not like the state should become smaller and just sit aside. It's different. And neoliberalism started as a political theory, not as an economic theory. It was a state theory. State and market actors, especially overseas actors, have to create safe markets, safe societies, safe economic systems, and it's all about what the state should do to establish such safe systems. So it's, in its essence, neoliberalism is a state theory, and the state theory put economic safety and security at its center. So the concept of terrorism, let me repeat, together with the neoliberal domination, became widely spread at global level, and it happened at the same time as the development of such a state theory. Then add to that the coup d'etat of the 1980. Of course, it brought along its own problems, its own state tradition, and actors that had the claim to represent that state at that time. So this structural transformation in Turkey, starting with 1980s with neoliberalization, it also became a concept of fighting against terrorism with the laws, anti-terror laws that were enacted. So there are both internal and external dynamics that are intertwined. So on one hand, we have the spirit starting from the establishment of the Republic of Turkey. You might call it colonialist approach, anti-law approach. By the way, I'm sorry, anti-law approach is a more recent approach. I said that, but I should take it outside that bundle of concepts. So starting from the beginning of the Republic, these practices have been adding up on one another. So the anti-terror dynamism we had in Turkey in the post-1980s period was coupled with the global trends. And there is a certain milestone, a global milestone that made things more difficult, which is the 9/11, the Twin Towers issue. So the paradigm of the state, together with that milestone, became a very concrete and aggressive state of emergency, a global state of emergency regime, let's call it. So it evolved into a global state of emergency regime. What we witnessed starting from the 2015 was also mentioned, and I think how you call it was very appropriate. Maybe just one emphasis. Yes, we are in a new era, a new phase starting with 2015, and it's still ongoing. And in the legislation of anti-terrorism, and as mentioned by the previous speakers frequently, as the report also talks about it, there is more and more ambiguity, and things are more vague when it comes to the way the Anti-Terror Act is being used. And it's also about the Kurdish movement becoming bigger, and the state wanted to counter that, wanted to restrict that. It's a very interesting thing. We are talking about an environment of conflict, or a history of conflict, let's say, and one party of the conflict, outside the armed conflict, who has never seen themselves as a part of the armed conflict, who wants to act in the legal field based on demands regarding identity, mother tongue recognition, a party that wants to get organized legitimately in the political arena is coming up with certain legitimate demands. One party is like that, but the reaction to that is all about eroding the existing laws, making the existing laws more vague, and it is actually a state practice in the end, because at the end, the Kurdish political movement and the non-violent actors of the Kurdish movement are coded as terrorists. So the state structured this as a way of calling them terrorists. This started with the Kurds, but of course it was not restricted to them. Now it's expanded to a large portion of the society. People are being labeled as terrorists. But one good news is that as the concepts of terrorism and terrorists are being so generously used, people take it less seriously. So as a person who has signed the petition, the peace declaration petition, we also thought it was okay to call ourselves as terrorists because the meaning of the word has changed now. Of course, it's not a solution to all our problems, but this is something that we are observing, and this wall of fear, as we can call it, is now being eroded. It works for that purpose as well. Okay, thank you so much for your time and attention. Thank you. It was a very nice presentation, exactly the kind of wrap-up we needed. So we just have a few minutes, so maybe we can continue with the Q&A session. If there are any questions, as I said, please write your question in the notes section on YouTube. And Serdar Tekin's presentation is linked to this. There's a question actually, maybe he can answer and other speakers can also comment. Let me open my screen. Writer Naomi Klein is referenced here. Naomi Klein says that in neoliberal order, you need violence and oppression, and the laws are interpreted accordingly, especially for US. In the post 9/11 period, we have the Patriot Act that was enacted. So the question is, based on this comment, is it possible for the Anti-Terror Act to be in line with human rights in Turkey or elsewhere? Is it possible to do that, to implement the Anti-Terror Act in line with the human rights? Maybe, Ms. Serdar Tekin, we can start with you. Well, very briefly, let me give you my general perspective. The Anti-Terror Acts, or this concept, or the language itself, anti-terrorism language itself, doesn't seem like something acceptable from a human rights perspective. When you have an anti-terror law, it means that you cannot or you don't want to tackle these issues within the framework of a regular, normal penal code. Concepts like citizenship, due process, etc., are not going to apply. Certain groups of people will be subject to another type of law or something that is not even considered as a law. And this is the expression I see is not in line with this concept. So these concepts of anti-terrorism is a peculiar one. The issue of security can be considered with different terminologies maybe, but to be able to do that, you need another type of politics. You need other societies that build that politics and the struggles of those societies, communities to build that politics. Security will always remain a problem, an issue, but from what political perspective security will be discussed and solved will change. I think that's the main question. And the language of terrorism and the concept of fighting against terrorism is one way of looking at security. And in the neoliberal world, coupled with these repressive practices, this is becoming more and more dominant. I think categorically we have to say no to this approach. That's what I believe. Yes, Eren Keskin, over to you. Well, I agree with what Professor Serdar has said, and something that we haven't discussed so far, or because my time was not enough, I was not able to discuss that. There is another act that is preventing the civil society, or that is causing a crackdown on the civil society. That's about the Convention on the Financing of Terrorism and the law on financing of terrorism. The Republic of Turkey did not sign this convention for a long time, but enacted the law. But the law is implemented totally contrary to the text of the law and the spirit of the law. Yesterday we were attending a case. It was about anti-money laundering and prevention of proliferation of weapons of mass destruction. So it's all about funding these types of things. So the law is about these things, but the legislation is formulated in such a way and it's implemented in such a way that the law itself is actually making this region a heaven, a safe haven for money launderers. So people who are money laundering money are not being prosecuted, but people who are maybe just sending 100 liras, 200 liras to prisons are being prosecuted. Yesterday in the trial we attended, the questions asked by the judge made us actually go crazy. Even visiting people who are serving time in prison is seen as something equal to engaging in terrorist activities. And you can't explain this to normal people, because they think if you are visiting a person in prison, you are also a terrorist yourself. So that's the mentality that they have. It's a totally different, non-existing world that they are creating. So they are creating these groups of people who are guilty, who are terrorists, and the regular people, laymen on the street believe this. They think the survival of the state will be at risk, that it will be damaged. So they are creating this perception that there are terrorists everywhere. And the laws that are enacted are actually implemented against their essence. For instance, Amnesty International has a report on this. The most recent law I talked about is not implemented against the real criminals, but it's against the civil society. Just as a footnote, I wanted to say that. Okay, next, Mr. Ali. Yes, as a global trend, state of emergency is now becoming the regular way of ruling countries. The neoliberal political approach is actually causing this, as mentioned by the previous speakers, and the use of the terms violence or terrorism is legitimizing violence by these powers, and many legal, political, and cultural areas are being impacted, and these powers are using these laws. Of course, it's unacceptable, but as we did not have time, we were not able to go into the details. Mr. Sardar emphasized important things, but one characteristics of the neoliberal system is that it's causing severe poverty at two levels. The poor percentiles are increasing, and it's horizontal poverty, and then the vertical poverty, because the poverty is deepened. So it's also becoming a political poverty. So all the objections that can be caused by that poverty, all the complaints that could be created are things that neoliberalism fears, actually. That's why they try to associate it with terrorism. In Turkey, the colonialist history goes through the Kurdish people on one hand, and on the other hand, it's also having another dimension on the socialist and leftist movements. But currently, the main threat for the state is, yes, we have the Kurds, but they are also using Kurdistan as a laboratory to prevent all objections coming from the society. It's a counter-terrorism initiative at global level as well. For instance, in 2011 and 12, one of the political institutions purchasing the highest amount of pepper gas was the London City, the municipality of London. In many European capitals, there was a similar trend. So emergency or state of emergency was becoming the usual rule. So they are using counter-terror initiatives as an excuse. And Turkey is also adapting to global trends and because of political reasons, because of the methods used since 1980 coup, the global neoliberal powers are also using Turkey as a laboratory in terms of the methodologies to be used. For instance, Trump imitating Erdogan is all about this from many perspectives. Turkey is not a country lagging behind Europe and monitoring the developments in Europe. No, such authoritarian, fascist, and administrative models needed by the neoliberal approaches are actually looking at Turkey as a laboratory to see the methods.
Anti-law, what I call the anti-law thing, is one of the things, Eren Hanım said this, is to stop the financing of terrorism. What is the practical implications? Well, the aid that is given to poor people who inhabit the prisons. What is really targeted here is that they um, they interpret this as financing terrorism, these 100 or 200 Turkish lira, and the logic, of course, is really ridiculous, but this will also have its copying in the West, like Trump did before. Now let's continue with Nuray Özdoğan. Well, there is the terrorism aspect. Yes, I think the Anti-Terrorism Act should be abolished. It's not only in Turkey but everywhere. Perhaps we can do a comparative judgment here. We have always been those who have been prosecuted, but then with respect to the ISIS, for instance, the Islamic State, we said the following. Why is anti-terrorism legislation not implemented for these people? Then we found this problematic and we discussed this among lawyers. So really we are making, desperate demands for this. The state does not fall into this kind of contradiction. It did not implement. Of course, it did punish some of the more salient examples, but that's all. Eren opened this question of financing. Well, many people to their children, to their next of kin, to their friends, etc., extend some solidarity. This attack eroded this solidarity because everyone who sent money to prison was prosecuted. There's not even a case of person that wasn't prosecuted. Well, at least there's investigation because they sent 100 Turkish lira or 200 Turkish lira to these people, and the system is based on property and money is very much needed in prisons, and the state made this both um, an occasion for profiting, but also they punish people because of their solidarity. People, don't know how to send their next of kin money. This is really terrible. Ali Duran Topuz touched upon is something important again. This is something usually missed. In 2016, during the period of the prohibitions, there is a legislation um, um, that was changed, and there was an additional provision. If 65%, more than 65% of a certain town or city is contravenes zoning principles, then this will be immediately made public, nationalized. And this, of course, was implemented only for certain parts of Kurdistan. Well, this means very, very important things for Turkey. Everywhere there is this hasty kind of nationalization because 90% of Turkish towns are against the, contravene zoning legislations. So this is one of the examples. There are many other examples, but let me add this to the whole lot. I would like to answer Serdar Hoca on a certain issue. I agree with what he says. Yes, I do agree that concepts should be used in the most plain manner, mathematically speaking, and what I'm saying is not an objection to what Serdar said, and we do agree on the concepts. But then there is the process of construction and comprehension of concepts, especially in Turkey, in order to understand the situation and to debate the question. This concept of colonialist law should never be ignored. Um, with respect to use and practice, there is no problem. Me, I also look at it as emergency law because this is a panel where we want to go deeper into history. I wanted to point that out. Thank you. Well, we have very little time. Let me ask everyone whether they want to add anything, whether they want to say anything, and then should wind up, perhaps. Eren Hanım, anything you want to add? Let me say the following additionally. As I said at the beginning, our major problem, fundamental problem, well, both government in power and the opposition come from the same source, from the same ideology. Well, for instance, violations of rights with respect to refugees or asylum seekers, or the great economic problems. Um, but what is most, important? Um, Well, the Turkish Republic really creates a kind of state outside the frontiers of Turkey in Syria, and it pays salaries to certain of its functionaries there, and these are not brought on the agenda by the political opposition. For instance, in very recently, these Cyprus question has its 50th anniversary coming. Nobody's talking about it. This is the command center of the Turkish deep state, and we have not discussed this. Um, the repressive system is determined by the state, but it has created such a system that it is the state again that determines our areas of grievance. This is one of the major problems that we have, and perhaps we should discuss these as well. Thank you for the invitation. It's us who thank you. Ali Duran Topuz. Ali Duran Topuz has to unmute. We cannot hear him. The, the moderator says you are muted. Sorry, this is not a matter to finish to hear. We have to leave it somewhere, um, but we should say the following. Every time we talk about law, we should remember that what makes law into law uh, is power. We should always talk about the power behind law that makes it a real law. Both for Turkey and globally, we tend witness a tendency that it destroys and eliminates the rights of the citizen. This is where we're going. Then we, in our discussion and debate, we have to really stress the unity of our forces that will fight against this. And for instance, in Turkey, a small example from the 1990s on, especially under the AKP, when Kurds and workers come together, students and workers, students and Kurds, academics and Armenians, when these come together, then the state is enraged, and this is very clear under the AKP, because what really they were after was to stop this kind of unity, because that unity is the only thing that would put an end to this travesty of law. Um, if law is to become really applicable, we have to also speak about how forces that can see to it that law becomes applicable will come together. We should discuss this as well. Thank you. Thank you very much, Nuray Özdoğan. I thank you for the panel, for this encounter, but I don't want to end this debate this way. We have to talk about all of this, but we have something and of an aim here. Democracy and peace have to be organized in this country. We have to create the instruments for this, or it's not only a matter of a question of legality. Let me give an example of this. During the Kobani case, in the decision, when the court interprets its decision, there are socialists, as you know, in Dem Party. They were punished very highly. This was they were discriminated against. Socialist friends who are not Kurds were really targeted. And this is an interesting decision that came as a result of the judiciary, the government, and all the forces that rule Turkey. It says, the decision, during their attitude, um, sorry, on the basis of their attitude during the proceedings, it is very clear that they are insisting on their position. So the court keeps the punishment high for those people who insist on their political struggle. So this struggle for democracy and freedom, the insistence on this question is punishable much more severely, obviously, for them. Well, whether it be a workers' struggle, whether it be a struggle against the administrators appointed to instead of mayors, whether it be some other struggle, but these are not decisions of the judiciary. These are really punishment for struggling for democracy and freedom. Thank you to the audience, and thank you to the organizers. Yes, finally, Serdar Tekin. I have nothing left else to say except for share their the insistence on the struggle. We have to unite our struggles this way or that in the coming period. Then objective conditions of life will bring us together. These are actors that have to come together, that need to come together. We will live to see this. Let us stand together. This is very valuable. Thank you very much, all of you, for having accepted our invitation. This is a kind of meeting that was very valuable. Well, today, this uncertainty, the arbitrariness, the contradictions of all the aspects of the legislation on the anti-terrorism in the anti-terrorism area. Well, we really started the book from 1980, but really we had to go back much earlier, perhaps all the way down to 1915. I would like to end by mentioning the names of our friends who did this. Banu Tuna, Burcu Balıktaş, Bingöllü, Özlem Zıngıl, Esma Yıldız, and Emel Akaktürk Sevimli. And this book will be published in the coming weeks. And please follow what we have done as the work. And I would like to thank you for being here, all the entire audience. Thank you. Sendik.
Vallahi.